Afternoon, everyone. We want to encourage you, I think, to continue eating, maybe as silently as possible, but we'd like to begin the program here, especially with our distinguished guest, Attorney General Pruitt of the state of Oklahoma. Attorney General Pruitt has one of those multifaceted resumes to envy. Georgetown College, followed by law school at the University of Tulsa, then a stint in private practice, later a senator in the Oklahoma legislature for 8 years with 4 years as the Republican floor leader, and for 7 years was even owner and managing general partner of the Oklahoma City Redhawks, a AAA baseball team. General Pruitt established the first federalism unit in the Office of the Solicitor General to combat unwarranted regulation and overreach by the federal government. He's a national leader in the cause to restore the proper balance of power between the states and the federal government, and he has led or is still leading charges on that front against not only the EPA, which is our subject today, but also on the Affordable Care Act and Dodd-Frank. Additionally, Attorney General Pruitt has not hesitated to break with his fellow state attorney generals when necessary. For instance, when he secured, consistent with law, millions of dollars in relief for Oklahomans harmed by unfair foreclosure practices in the mortgage industry. And he's also acted to protect the most vulnerable child citizens of Oklahoma by negotiating a landmark settlement designed to dramatically improve foster care in the state. So it is the Federalist Society's honor and pleasure to have the Attorney General here to speak about his plan concerning Section 111D of the Clean Air Act. So give a good welcome to Attorney General Pruitt.
Multifaceted experience or that's right. Baseball to law. I mean, it's a wonderful life that I've been able to be a part of. And you know, sometimes when I'm introduced, I played baseball at the University of Kentucky, and sometimes the mistake is made that the folks introduced me saying I played basketball at the University of Kentucky, and then I step out from behind the podium and people see my very imposing stature and they say, "You didn't play basketball at the University of Kentucky," and that is a true statement. It's been a wonderful year for me personally. My daughter has gone on to college and done very well. She's back home, so we're excited about that. I heard all these stories about kiddos who go away to school who don't stay in touch. They don't email, they don't write, they don't call, and McKenna has stayed in touch because she needs money, and so it's gone very well. But I read with interest a little story last year about a young lady who had gone off who didn't stay in touch, and she wrote a little missive to her dad toward the end of the year saying, "It's been a great year, Dad. Things have gone really well. The dorm did burn down, and I did lose all my personal effects and textbooks, but I found a new place off campus to live with a new roommate, Jim." And Jim is doing extraordinarily well. He's been in recovery for almost 6 months now, and I know that we have not stayed in touch, and I've not written, and I fully understand why you didn't make it to the wedding, but I know that you're not going to miss the impending birth of your new grandchild. And she signs it and says, "Sincerely, Dad," and signs, "P.S. Everything above is untrue. I did flunk chemistry. I just wanted you to keep things in perspective." You know, and I tell you that the life that I live as Attorney General, particularly on these issues we're going to talk about today, we've got to keep things in perspective because they are very difficult issues that we're dealing with from a state vantage point, and they're very adversarial, uncertain times for the states. I'm going to talk about that a little bit today. I want to say first and foremost, thank you to the Federalist Society. I don't see my good friend Leonard Leo. I know he's coming because he told me he's going to spend some time with me this afternoon, but I do see Jonathan in the back, and I want to say thank you to the Federalist Society for putting this event on. It's very kind of them to do that. It's going to be a very engaging and I think thoughtful and productive discussion today. You know, one of my favorite books recently, and when I say recent, in the last 6 or 7 years, one of my favorite historians is Joseph Ellis. And he's written several books, but one of the books he's written is called Founding Brothers. And there's a chapter in this book that I want to call to your attention just briefly as a kind of a narrative for my comments today. And it's a chapter dedicated to something called The Dinner. And it was a dinner that took place between Alexander Hamilton and James Madison and Thomas Jefferson. If you study history, which many of you in this room do very, very closely, you know that Alexander Hamilton and Thomas Jefferson were not the best of friends. They did not trust each other a great deal, but particularly around policy issues. And there was a very important issue that was being debated in the early 1790s after the Revolutionary War, and it was all the debt that obviously the colonies faced. The federal government was contemplating consolidating all that debt at the national level, at the federal level. And Alexander Hamilton, as the Treasury Secretary, was pushing that, advancing that. And as you might imagine, Jefferson and Madison were very concerned about that consolidation of power in the federal government. And so they fought it. They had a dinner. They got together, which doesn't happen very much these days in Washington, D.C. They got together as adversaries, as competitors, as individuals that were dealing with some very consequential issues, and they worked it out, and the bargain that they struck was that Madison and Jefferson would not oppose the Assumption Bill, as it was called, in exchange for what? The capital, the U.S. Capitol, being moved from New York City to the shores of the Potomac. And that's why our capital is here as we gather today. But that story is something that I want to share with you because, you know, David and I were just visiting. These are big consequential issues that we're dealing with as a country in the energy/environmental space. And Oklahoma, many of you know that we're very, very active in oil and natural gas. We do have wind sweeping down the plains, as you know, so we're very, very involved with renewables. But we also have coal, and we have the production and development of coal in southeast Oklahoma. So we're very vertical with respect to our energy development and production. And one of the very important things about our state is that our state historically has provided very low energy cost on electricity to our manufacturers and our residents and consumers. And in fact, it's been one of the primary things that has allowed us to grow our economy compared to Texas and others around us because their tax rates are higher, and it's been a market advantage for us. And so these issues that we're dealing with respect to energy and environment and the EPA's role and the state's role are as micro as what it costs to turn on the lights that we're here today. And I have a responsibility as Attorney General to represent ratepayers before the Corporation Commission, as we were talking at my table earlier today. And the demands upon utility companies today is substantial. You have these environmental mandates that they're faced with, along with all the other issues they deal with, and the combined, it's presenting I don't want to say a perfect storm, but it's presenting a rather difficult situation for consumers, not only in Oklahoma, but across the country. But I don't want you to hear that our challenges in Oklahoma are somehow just unique to Oklahoma. I think many states across the country are facing exactly what Oklahoma is facing. And my purpose in being here today, these gentlemen are going to discuss the merits, very few demerits, David, of the Oklahoma plan. But you know, I wanted to provide more of a big picture on the plan as a whole. And to start with, you know, it's very important, I think, to recognize that there are some global issues up front that I don't endeavor to yield. And our discussion about the procedure or 111D and the role of the states and the role of the EPA doesn't necessarily mean that myself or others yield to the fact that you take mass versus EPA and somehow extrapolate from there that though CO2 has been considered an air pollutant under that case, does it necessarily link to, with it being non-stationary sources to stationary sources and existing sources, what authority and power does the EPA have? I think that's a fundamental question I'm not going to get into today, but I think it's a question that perhaps will be litigated, will be discussed, will be a source of contention on a go-forward basis. But I think even more than that, globally, I think there is a significant interplay between 111D and 112. As you know, Section 111D says that the EPA cannot regulate categories of facilities regulated under Section 112. And these existing stationary sources are regulated under Section 112. And so the weather, I think, has been resolved on CO2 and whether it's an air pollutant or not, hazardous air pollutant. The how, I think, is what we're here to talk about today. What is the procedure? What are the steps that the EPA should and shall go through as it relates to cooperative federalism and the role of the states? And I think in that regard, I was just sharing at my table, Oklahoma is a little bit sensitive to that in light of our experience under the Clean Air Act with the regional haze situation. The regional haze statute, just to unpack that briefly, in fact, we're seeking cert as we speak before the Supreme Court. We're hoping to hear on that very, very soon. But that statute, that section of the Clean Air Act is very specific as it relates to the authorities of the states in setting up a state implementation plan. And Oklahoma did that in 2010. And as you know, under the regional haze statute, we have obligations that have to be met by the year 2064. Oklahoma met those obligations, but despite meeting those obligations, the EPA swept into Oklahoma. Lisa Jackson swept into Oklahoma within 3 months after having been sworn in as Attorney General and rejected the state plan and simultaneously issued a federal plan for one reason and one reason only. They just disagreed with the methodology, the decisions made by the state of Oklahoma, not the results, not the outcomes, not whether there was compliance with the statute, but simply based upon an attitude that says, we know best. And the EPA, in my estimation today, is using its regulatory power to pick winners and losers, to elevate certain energy sources at the expense of others, particularly fossil fuels, obviously. And in this instance, coal. And that is not the proper use of regulatory authority. The EPA has an attitude, it's almost like form over substance. So long as we agree with the state's decision-making, so long as we agree with the state's methodology as it performs its responsibilities under the statute, so long as we agree with that, you can put that in the state plan. But if we disagree with that, we're going to FIP the respective states. We're going to force ourselves upon the respective states across the country, and I believe in certain instances exceed its authority under the statute, and that's what we're here to talk about. So that theme is very, I think, evident as it relates to 111D, and it's very timely for us to be gathering here in the beautiful month of May in Washington, D.C., because on June 2nd, there is going to be an unveiling by the President himself of what the EPA is going to pursue under Section 111D, the how portion of CO2 regulation. And there are 2 or 3 things that I want to draw your attention to with respect to our plan, Oklahoma's plan, and it's intended to be a counterpoint to the plan offered by the Commonwealth of Kentucky. And you notice I said the Commonwealth of Kentucky. See, having grown up there, having been born there, it's, just like Virginia, I recognize those things, but the Kentucky plan is something that has been put in the marketplace, I think, within the last 3 or 4 months, and it is intended to address the proposals that are going to come out of the Climate Action Plan by the President. And so it's a view from a state's perspective on the relationship between the state and the federal government under the 111D umbrella. And the primary thing that I find objectionable and that our plan deals with respect to the Kentucky plan versus our plan is that it takes a mass emissions approach as opposed to a unit-by-unit analysis from a state perspective. It effectively establishes a capitated or a cap and trade without the trade. It says to the states across the country, here's what the emission standard should be for your state. Now, you figure it out from there. Now, as that occurs, as a capitated objective is defined on a state-by-state basis, it seems to run counter specifically with the language in the statute. And that's one of the things that I think that editorially I would share with you. Congress has been very specific since the 1970s, as these environmental laws were passed and signed into law, that it is very important to have the involvement, the partnership of the states in the regulatory process. November of last year, I testified before Congress. Ms. McCabe, who heads the Air Division of the EPA, testified before me and said all of the right things about the respect that the EPA has and the role of the states in each of these key areas that we're talking about. And I followed Ms. McCabe, and the chairman asked me shortly thereafter, how's that working for you? And my answer was, not very well. This form over substance, this attitude that says we know best, this dictatorial attitude to say, so long as you agree with us, then everything is kosher and everything's okay, is exactly the opposite of what Congress has said repeatedly in the role of the states. The states have a meaningful role. It's not an administrative role. The states are not a vessel to carry out the desires of the EPA. They are actually there to make important decisions, balancing factors between industry and consumers, and meeting the obligations of air and water quality in their respective states. That's important to recognize. And I think the attitude here in this city, and the attitude amongst the regulators, and the attitude at times amongst those that come into our states is that we're going to change that and review that and make sure that the states are acting merely in an administrative fashion. Listen to this quote by Justice Frankfurter, because the statutes are clear here in many instances. Justice Frankfurter said this: standards must be enforced to be respected. If they are merely left as something on paper, they might as well be written on water. That's what we're facing as a collection of states. We're trying to give meaning and life to the words as drafted by Congress and making sure that our responsibilities are protected and we can actually do our job as provided for by statute. This mass emissions unit-by-unit review is something that is, I think, the primary point, the primary distinction between the Kentucky plan and the Oklahoma plan. You know, this arbitrary emissions baseline that's made upline at the state level and then affects all decisions downline on a unit-by-unit basis. It takes away the discretion to the states, and you find that in our plan. The second thing that I wanted to highlight for you, I think the distinction between the Kentucky plan and our plan as it relates to 111D, and it emanates from this mass emissions approach versus an inside-the-fence approach, is that it takes discretion away from the states as far as making decisions about more or less stringent standards on a unit-by-unit basis. The statute says very clearly that states may prescribe on a case-by-case basis for particular designated facilities or classes of facilities less stringent emission standards upon unreasonable cost of control, physical impossibility, and other factors specific to the facility. Now, how do you do that as a state if you have a mass emissions approach and a capitated approach as presented by the Kentucky plan? We're hopeful that the EPA is more persuaded by our position in the plan. And then the third thing I would mention to you that I think is center to our proposal is that it maintains primacy of the states. You know, I reject, in fact, I find it offensive, that regulators in Washington believe that regulators in the states somehow aren't interested in the air that we breathe and the water that we drink in our respective places that we call home. I reject that utterly. In fact, I would say to you that Washington, EPA, other agencies that are involved in these areas could learn a lot with respect to the expertise of the states. You know, this is an aside. Hydraulic fracturing, the regulation of that, our involvement as a state. You know, in certain sectors of the country, they think that that's a new technology or a new phenomena. We've been regulating hydraulic fracturing since the late 1940s in the state of Oklahoma. We have a very robust regulatory regime, tremendous expertise. And I think that this attitude that regulators at the state level are somehow dismissive or disregard the importance of air quality is something that I find unfortunate. And the federal government and the EPA, through its 111D proposal, can recognize the importance of the states as relates to primacy. And this primacy is not something that is editorial. It's not something that is that we're asserting. It is something maintained and protected by the statutory constructs that Congress has put out. And so these areas are important on primacy, and we need to make sure that we protect them, and that's what brings litigation to the bear, Jeff. As you were introducing me, I've kidded Greg Abbott in Texas. As I came into office, I think he had roughly 13 or so lawsuits against the EPA. I'm trying to catch up. We only have, I think, 6 or 7, but I met him the other day in Oklahoma. We were having an event for him in Oklahoma, and he's up to 31. Now, let me say to you, as I share that with you, I don't want you to hear that we at the state level are simply trying to find ways to challenge or sue the EPA. There are multiple examples. We have to prioritize, unfortunately, and it is in response to this attitude of command and control, as I talked about earlier, a DC-centric viewpoint that states cannot be trusted to exercise authority given to them by Congress to meet the objectives and goals established under the environmental laws. You know, Oklahomans care about their air quality, they care about their water. We want clean air and we want clean water, and we've done it very, very well for decades. And that balance between consumers and industry and meeting the demands of environmental regulations by Congress is something we will continue to do in a responsible way. And our proposal that they're going to talk about today is an effort to establish guidelines for the EPA as the proposed rule comes out June 2nd. I'm hopeful that our proposal will find persuasion with the EPA, and as the rule is finalized in June of 2015, it will recognize that a mass emissions approach is not the way to go, that a cap and trade without the trade is not the way to go, that a unit-by-unit, inside-the-fence strategy that gives discretion, maintains discretion to the states to balance these factors, to evaluate cost, to make sure that all factors at the site are considered, will be maintained. And it is a pleasure to present that to you today, and I'm hopeful that the discussion that we have together will be more instructive as we finish our lunch. So thank you, Jeffrey. Thank you for the time for the opening comments, and I wish the panelists well as they discuss the Oklahoma plan. Thank you.
So thanks, Attorney General Pruitt, for the, yes, there's a spot here for you right there. And actually, why don't all of our panelists come up and then I'll introduce you. I wanted the Attorney General to be the star of the show, so let me at this point introduce myself and the other panelists. I'm Jeff Clark from Kirkland & Ellis, and I'm the chairman of the Federal Society Environmental Law and Property Rights Practice Group. And we have two panelists here with us at the moment to discuss the Attorney General's paper. And we're hoping to be joined by a third. He is a staffer on the Senate, and he's held up by a hearing there, but we hope he'll be joining us late. Let me start out by introducing David Doniger, who's sitting at the far end of the table. He is director of the Natural Resource Defense Council's Climate Change and Air Program, and Clean Air Program. He previously served as an attorney at the NRDC and as an advisor in the Clinton administration, primarily as director of the climate change policy issues at EPA, where he helped to negotiate the storied Kyoto Protocol. He's been involved in numerous high-profile lawsuits and policy initiatives related to carbon emissions, dating back to that time and going forward into the present. In the middle of our present panelists here is Bill Brownell. Bill Brownell is the chairman of Hunton & Williams, LLP, where he previously led the administrative law group and the environmental law team. His practice covers a broad range of environmental issues involving proceedings before federal and state agencies, courts, and Congress. He has represented the utility industry in proceedings under the Clean Air Act for over 30 years. I will introduce our third panelist and then remind you of him a bit, hopefully when he joins us late. That third panelist not yet here with us is Patrick J. McCormick III, I'm sorry. Pat McCormick is a Republican chief counsel to the Committee on Energy and Natural Resources of the United States Senate. Prior to assuming his current role in 2011, he was a partner at Hunton & Williams and specializing there in energy regulation and infrastructure development. Earlier in his career, he served as an attorney with the Federal Energy Regulatory Commission and in the private sector at the Potomac Electric Power Company. So with those introductions out of the way, let me actually then tell you about the format. So we're going to hear from each of our panelists in turn for about 8 to 10 minutes. And then we will take questions and probably a little bit before the questions have some reaction and discussion amongst the panelists. So by agreement, David has kindly agreed to go first. And so with that, David, I turn it over to you. Oh, Bill, you had agreed to go. Sorry about that. It was very kindly, even though I erred and said it was David instead of Bill. Thanks a lot.
Okay.
Yep.
Thank you, Jeff.
Sure.
And thank you to the Federalist Society for making this forum available. This is both an interesting and timely topic. As you all know, there's been a lot of policy debate on this issue of Section 111D regulation over the past year or so. And I thought this morning what I would try to do in the little bit of time I have is just to go back and look at the statute and look at the statutory language, because that ultimately is what defines the scope of EPA's authority. One of the things I remember from law school was a comparative law course. The one thing I took away from it is the difference between a common law country and a civil law country. The professor said, common law countries, everyone's worried about precedent. Civil law, you look at the statute, you look at the regulations. It's so important, even in a common law country, to look at the statute, read the statute, read the statute, read the statute. And I think that's really important here as we go into this Section 111D process. First, Section 111D talks about standards of performance for existing sources. It talks about the performance of sources, standards for the performance of sources. Not about what other sources do, not about demand-side management, but what is the performance of the source. Second, in terms of the EPA's regulatory responsibility, it says EPA must provide a procedure by regulation, a procedure similar to that under Section 110 of the Clean Air Act, the State Implementation Plan provision, for developing state plans. So these regulations that EPA is to develop are procedural. Procedure for states to develop state plans. The states then develop the plans. Third, the statute goes on to say that the procedures under which a state develops a plan address two things. One, they address the performance standards for the sources, for the existing sources. What are the performance of the source? Second, they address implementation and enforcement of those performance standards. Now, what guidance does the statute provide for those plan contents, both the performance standards and the implementation and enforcement provisions of the state plan? Again, these are state plans, the state has to develop them. Well, a standard of performance is defined in Section 111 as a standard of emissions for emissions of air pollutants that reflects the degree of emissions limitation achievable using the best system of emission reduction that the EPA administrator determines has been adequately demonstrated. So the EPA administrator has a role. He determines what systems of emission reduction have been adequately demonstrated, but then the state formulates the plan, defines the standard, takes into account the systems of emission reduction that have been determined adequately demonstrated to define a performance standard that's achievable. Important role for the state. As important, perhaps more importantly, Section 111D then goes on and says in formulating these plans, the states are to take into account remaining useful life of sources and defining the performance standards for the sources, among other factors. It's very interesting, remaining useful life among other factors. Well, what are those other factors? Those are the factors that states commonly consider, for example, when they develop state implementation plans that reflect the local and state considerations and conditions that inform common sense regulation. So that's all the state plan. Now, if a state does not adopt a plan, EPA has what's called FIP authority under 111D. EPA can come in and impose a federal implementation plan if it finds the state plan is not satisfactory, where there's an unsatisfactory state plan. This is not an equivalency test. Is the state plan satisfactory? Similar to the law that's developed under Section 110, which is the starting point or the context for the procedural regulations that EPA issues, satisfactory is established by consideration of the appropriate range of factors under Section 111D in formulating the plan, the factors that we've talked about. State considers the factor its plan is satisfactory. Now, of course, there are other limitations on EPA's authority with respect to Section 111D standards. Some of them were referred to by General Pruitt. For example, as General Pruitt mentioned, if a pollutant is regulated under Section 108, 109, the Ambient Air Quality Standards Program, or under Section 112, you don't regulate it under Section 111D. If the source category is regulated under Section 112, you don't regulate it under Section 112, under 111D. Further, there has to be a new source performance standard in place for the source category. Section 111D talks about applying performance standards to existing sources that would be subject to a standard if the source were a new source. And that, of course, raises a whole range of additional issues. There's a proposal out there right now, the comment period just closed last week, on new source performance standards for greenhouse gases for the electric utility industry. Lots of issues with respect to whether that will go into place or not at the end of the day, including this very important issue of the Energy Policy Act, which limits the authority of EPA and others to rely on DOE-funded projects as the basis for an adequately demonstrated technology determination. So that all is being debated in the context of that rulemaking and related litigation. Now, there are other considerations that I'm sure we can talk about during the discussion, but I wanted to lay out the statutory structure for you just briefly at the beginning of this, because I think it provides important context for the discussion, and it very clearly delineates, I think, the roles of EPA and the roles of the state in developing plans and regulating under Section 111D. At the end of the day, I wanted to just quote a sentence from a brief that NRDC filed in the DC Circuit on trading, and I'm sure David will have something to say about this. Under Section 111D, this was in the context of the Clean Air Mercury Rule, issue never ultimately joined by the DC Circuit because they vacated the program on other grounds. But trading is unlawful. The statute mandates that each state plan under 111D apply the best system of emission reduction to any existing source on a source-specific basis. That's Section 111D. Jeff, those are my remarks, and I'm happy to take questions later.
Sure. Thanks, Bill, for those remarks. And I've recovered from my misordering earlier. It would actually be Pat's turn, but he has still not joined us. So now it is David's turn. So David, if you would join us, that would be great. Thank you.
Thank you very much for inviting me to the Lion's Den. And I have to confess that the first time I spoke in front of the Federalist Society, I was under the misimpression that I was going to be addressing the World Federalist Society, and I came rather unprepared. But I hope I'm a little better prepared this time. I thought, what is Boyden Gray doing in a meeting of the World Federalist Society? And suddenly I realized what was going on. So I want to stipulate, at least for the purposes of today, nobody else has put this point in play. I want to stipulate, at least for my purposes, that climate change is a very real problem. The science is strong, the threat is real. You all are familiar, many of you are familiar with the reports that have come out in the last few months, just icing on the cake of further scientific studies showing that the problem is real and the impacts are already on us. So our goal is to do something to abate this pollution, to abate it in the United States in concert with a program of negotiation with other countries to get them to take on their roles. But now let me just talk about the U.S. role. The Clean Air Act is an important tool, a law already on the books, for addressing the climate change problem. And that's not just my opinion. It's actually been determined, that actually has been determined 3 times by the Supreme Court already. Once in Massachusetts versus EPA with respect to vehicles. In 2011, also, that the Supreme Court held that the Clean Air Act empowers EPA to regulate carbon dioxide from power plants, and that was part of its disposition of a tort suit on the climate issues. You can't bring a federal common law case because this is EPA's job under the Clean Air Act. And more recently, after the EPA issued the endangerment determination and the motor vehicle standards, there was litigation to challenge those, and also some permitting regulations that follow from the motor vehicle standards. The Supreme Court pointedly denied the cert petitions on all matters except those permitting issues, saying we're not going back there. And at oral argument, Chief Justice Roberts said we're not going back over that again. Justice Kennedy said this is settled law, American Electric Power in Massachusetts. So, the American Electric Power case is a riff on Section 111 and 111D. So this is not virgin territory to the Supreme Court. The Obama administration issued landmark vehicle regulations in 2010 and 2012. The vehicle industry, car industry, is currently making cars that comply with these standards, and they go out to 2025, so that at that point, the vehicles will be getting twice the mileage and emitting half the carbon dioxide and other greenhouse gases that they did just a few years ago. This is a major achievement, and the auto industry is prospering under this. The power plants are the only source larger than the transportation sector. 40% of the CO2 in the country comes from power plants. You can't address the problem of climate change unless we address power plants. So let's put aside for a moment the new source rule. Happy to answer questions about that, but we're here to talk about the coming approach to existing sources. And EPA has been engaged in an outreach, a stakeholder process, direct engagement with states, with air regulators, with public utility commissions, with utilities, with environmental stakeholders, others, all across the country since August of last year, the proposal coming out this June. This is the most massive pre-proposal stakeholder outreach and engagement process that EPA has ever held, to my knowledge. And they have solicited and they have got lots of input from states. My favorite piece of input is actually the letter from the state of Texas, the Texas Environmental Agency and the Public Utility Commission, the first 2 or 3 pages of which say, go away, forget it, we hate you, don't do this. And the last 7 or 8 pages say, when you do this, please structure your regulations to give us credit for all the good things we've been doing on energy efficiency, wind energy, and the transition from coal to gas. I thought that letter was really interesting because the proposals in the latter half of the letter closely mirror the thinking that NRDC has put forward about how the power plants standards could be set to achieve the most carbon reductions at the lowest cost and with the most flexibility for the industry and for the states. The first thing in our plan, which we published in 2012, we updated it in March of this year. The first element of our plan is the recognition that the power sector is different in every state. The mix of generation, coal versus gas, for example, is different in every state. And since the Clean Air Act, this part of the Clean Air Act calls for federal standards implemented through state plans, it makes sense to account for the diversity of the starting point that the states have in the structure of the standards. So we recommended that every state be given a baseline, which could be in 2005 or 2008. What were its emissions at that point, and what was the mix of coal versus gas in that state? There's been a lot of transition towards gas, towards renewables, buildup of energy efficiency, and every reduction that came from those transitions, no matter whether they were induced by regulation or by markets by happenstance. Everything counts, including, for example, under our plan, increases in output from nuclear plants. Any kind of zero emitting generation counts for credit towards reducing the emissions of the system of power plants in a state. And we don't think it makes sense to limit the view to the relatively minor modifications that a plant could make on its own site. Why should it not have more compliance options than just that? It should have the option of getting credit, in effect, from switching from the dispatch between the units in a company's fleet more towards the cleaner ones, away from the dirtier ones. This is happening already. Why shouldn't they get credit for it? And then why shouldn't that be built into the further improvements that a standard might require looking out to 2020 or 2025? The cheapest way to reduce emissions, and actually it results in lower consumer bills, not higher consumer bills, is to emphasize energy efficiency in buildings and in the machinery, the appliances, all the goodies that we use that consume electricity. If they are more efficient, you don't need as much electricity, therefore you need less generation. That less generation results in less pollution. There should be a way to get credit for that. So we propose formulas in which increases in efficiency become a compliance option for the operator of a coal plant or a gas plant. I'll be happy to take further questions about how all that stuff works. It's not overly difficult. It's complicated, but it's not hard. There's a difference. And so we propose a standard that takes into account those opportunities, differentiated state by state, graduated over time. And we ran the proposals that we came up with through the same model that the utility industry uses and the EPA uses, the integrated planning model of the ICF Corporation, to see what it would cost and how much emission reduction you would get if you posited this set of standards or that set of standards. And we proposed combinations of standards that can achieve as much as a 35 or 40% reduction in the total fleet carbon emissions by 2020. Really dramatic reductions. And yet they would cost less than the mercury and air toxic standard. And when you do cost-benefit analysis, in which you take into account the cost, the benefits of achieving carbon reductions, again, if you accept the science, which I stipulated at the beginning, at least for me, and when you take into account the public health benefits that come from further reducing sulfur dioxide and nitrogen oxide emissions, you end up with $30 to $60 billion in quantifiable dollar value benefits as against the roughly $10 billion in costs to impose, to comply with these standards. So we think this is a massively good deal on a cost-benefit basis. It's legal under the Clean Air Act. This question, by the way, whether Section 111D can't be used because power plants are regulated for other pollutants under Section 112, I predict that will take the courts less than 5 minutes to dispose of. And I'll explain why if you have questions about that. But it's a classic Chevron ambiguity question, and it will go very quickly. EPA's been upheld most recently in the Homer City case. It's not exactly on point, but it's an analogy, analogous provisions, analogous problems. A very ringing affirmation of EPA's authority and responsibility to solve problems that come up even if they were not entirely precisely anticipated, because that's the way the Clean Air Act is written, is to give EPA that authority and responsibility as long as they do it reasonably and rationally. And that opinion was joined by Chief Justice Roberts and Justice Kennedy. So we think EPA is operating from a very strong position. They have a serious responsibility and a big opportunity. But at the same time, we want to see every state have proper differentiation and proper access to flexible compliance. We want to do this as cheaply and as reasonably as possible. And NRDC is open to, very eager to talk to anybody about how to do this in a sound way. Thank you very much.
So we have been joined, thank you, David, and we have been joined by our fourth panelist, Patrick McCormick, who is Chief Counsel to the Senate ENR Committee. So Patrick, if you would join us.
If you don't mind, I'll just stay here. Forgive me for, I don't mean any disrespect by not taking the podium, but I have some notes and I'd just be more comfortable here. First of all, thank you very much for having me, and I apologize for my being late. When I was in practice and I used to come to events such as this one, it always annoyed me that the guy from the Hill showed up late, didn't listen to the material, and had things to say that were so ephemeral I could read them in the trade press tomorrow. So, so I apologize for fitting the bill. I also want to commend the Federalist Society for engaging this debate, which I think is very important, and obviously for the Attorney General for writing this very thoughtful paper, and especially David for coming and being part of this discourse, which I think is very important. On our committee, the senators on both sides of the dais have a real commitment to discourse about the subjects that divide us, and it's good to be with you. I should say also, by way of disclaimer, that obviously my views here are my own. They're not the views of any senator, certainly not of Senator Lisa Murkowski, who is our ranking member. And as much as I would welcome the opportunity to be the chief counsel of the committee, I am in fact the minority chief counsel, a situation that may change imminently, but we don't know. With that having been said, I should say, you know, my colleague Margaret Caravelli is here, and her committee has jurisdiction, or the committee for which she is a staff person, has jurisdiction over the Clean Air Act. And while it is true that I was once a partner of Bill Brownell, I really don't pretend to know even the things he has forgotten about the Clean Air Act. So,
Some of them weren't true.
well, they may have been true. They just may not have been affirmed. but in any case, so I will leave to the discourse you've already had about the proper reading of Section 111 and all of that. So you might ask, after all that, why would you take up space on the panel with me? And the reason that I would suggest to you that maybe it might be worth considering as part of this conversation is that from the time of the I think it's called the Ash Memo, which is the memorandum that went to President Nixon outlining the cause for EPA. From that time, there was, and if you haven't read that memo, I really commend it to you. From that time, there has been a real concern about balance and the rule of law and not having environmental regulation completely swallow regulation of other kinds. And that concern is one that's been wrestled with by the Congress, certainly, and certainly by the courts over time. I would say that as we think about Section 111D and how it might be implemented here in the next year, 2 years, 5 years, we really do go back to those fundamental questions. And the fundamental question for the senators on our side of the dais, on the Energy Committee, and I think too, in addition to Senator Manchin, some others on the other side of the dais, is how do we assure what Senator Murkowski says repeatedly and has written on extensively, abundant, affordable, clean, diverse, and secure energy. And specifically with respect to electricity, the key to that is electric reliability and the affordability of electricity. And those issues are very squarely within the jurisdiction of our committee. And the reason I was late is that I came from the confirmation hearing for 2 nominees to the FERC, one of whom is already serving there, and although we disagree with her on policy grounds on many things, including the administration of FERC's authorities as they relate to the administration of EPA's authorities, she is a very, very studious and very fine and balanced commissioner whom Senator Murkowski strongly supports, and indeed is perplexed as to why she's being demoted in favor of the other nominee, Norman Bay, who was also before the committee this morning. Mr. Bay is the enforcement director of the commission, and the president wants to promote him not only to the commission but to the chair. I tell you that because in the hearing I just came from, 111D was indeed a subject of discussion. And that's not surprising because, of course, the Kentucky plan, and David, I apologize, I have not read your paper, which is cited in the Attorney General's paper, but the Kentucky plan essentially calls for, I think the Attorney General called it a mass emissions approach. And that approach is very similar to cap and trade, which you know, the Waxman-Markey bill was jurisdictional to our committee, and Congress never moved on that. And in fact, in the Senate, it's interesting to recall that the Waxman-Markey bill was, or the Senate variant, was on the calendar for many, many days, indeed months, almost a year, in fact, at the time when the majority, the current majority, commanded a greater than 60 vote margin, and yet it never came to a vote. And so the points that the Attorney General makes, I think, are very consistent with the overall themes that Senator Murkowski and the people on our side, the senators on our side of the dais have taken, which is that we want to, the environmental, we don't have jurisdiction over the environmental laws, but we want to see that the environmental laws are administered according to their terms, and they are not supplanting the energy policy of the United States. And so I thought that some of the points in the Oklahoma plan were really right on target in terms of trying to get back to that balance. And a concern, although I like the idea of flexibility, and I seem to recall, and David or Bill, you all can correct me, but I seem to recall that the idea of mass emissions or a sort of overall cap was a Republican idea originally, and so I like the flexibility that it affords, and I credit David for wanting to work within that flexibility. But as the Attorney General's paper points out, and I'm sorry I don't have the quotation right at hand, the flexibility offered under the Kentucky plan is under a guise of flexibility because of the vast authority that it by definition would exceed to the EPA. And so that's my reaction from my perspective of the panel, and I hope that it is helpful.
Thank you. Let's proceed this way, if I could, and with General Pruitt's indulgence, if I could ask perhaps for your reactions to the panelists first, and then I'd like to exercise my prerogative as the moderator to toss out the first question to the panel. So, General Pruitt.
Well, thanks, Jeffrey, and really I appreciate the comments by all the panelists. One of the things that, David, I did want to ask you about with respect to, you made the reference to emissions baselines based upon historical, you pick a year, 2008, 2010, that recognizes the steps that states have taken historically. How do you reconcile that emissions baseline approach that would be defined on a state basis with the language that Bill cited in his comments, which, just to reiterate, Congress explicitly required the EPA to allow the states to permit the state in applying a standard of performance to any particular source under a plan to take into consideration, among other factors, the remaining useful life of the existing source to which the standard applies. So clearly Congress contemplated that the states were going to look on a unit-by-unit basis with that type of language, at least from my perspective. Do you not see any kind of conflict there between that language and an emission standard that's based at state level?
That's a good question. Thank you. The language of remaining useful life doesn't have a definition. You can think of a number of different ways to define it. Focus might be on how old a facility is, or its economic value, how much is economic value has it got left. Whichever way you think about that, I do believe in the approach that we're suggesting. The states have, and in fact the power companies have, the ability to take into account the useful life, the remaining useful life of a facility. For example, under the proposal that we've launched, actually it turns out that Oklahoma is the 50-50 state. It's the state which had an equal dependence on coal and gas-fired power in the baseline period that we looked at, just hypothetically, which was an average of 2008 to 2010. So if Oklahoma had that distribution, and then a standard was established, it's essentially a formula, this much for gas, this much for coal, and in your case, it'd be equally balanced. But there's a lot of flexibility in how to achieve that. So if you wanted to keep a particular coal asset or a particular gas asset running longer, you would be able to use the mechanisms I described of crediting, basically of doing something else, in order to cover the emissions of that plant to the extent it was over the limit. And so there would be total flexibility at the state level or at the corporate level to decide how long to run each facility as long as its emissions were properly covered. If I may, let me just say that our proposal is not a cap and trade proposal. There's no cap in the NRDC proposal. We proposed an emission rate. It would be a rate, as I said, differentiated from state to state. But it would mean that if power demand went up in a particular fast-growing region of the country, the rate could still be met, but the mass emissions might go up, but it wouldn't be required to meet a given cap. What our proposal does include is an option at the state level for states that want to use cap and trade approaches, that want to use mass-based approaches, to choose to do that and to convert from the rate-based, you multiply the rate by the expected electric demand in the year 2020, and you end up with a number of tons. And if the state wants to manage its situation under a cap and trade-based formula, so be it. Now, the eastern states and California already have those kinds of programs. Kentucky has expressed some interest in it, but it would be a Kentucky choice. Montana has expressed some interest in it, but it would be a Montana choice. And other states, under our proposal, could continue to operate with no caps, although there would be these emission rates and averaging and trading between sources in order to achieve the most reduction feasible at a reasonable cost.
Thank you, David. So with that, you're going to be a popular panel member because the first question that I want to put actually is to you. So it's giving you a lot of the speaking time. So first, in terms of your remarks, I do think that the science is contestable, and I also think that your interpretation of cases like American Electric Power are contestable, but we're not here for that purpose. So let me stipulate that they're just not on the agenda for today. The issue for today, it seems to me, and you've been addressing it, is compliance with Section 111D's terms. And you said that it would take the Supreme Court or any court all of 5 minutes to reject, to reject an argument that, what the EPA is doing here, or we suspect that they will be doing, is improper. I think there are three key textual limitations, and last time I checked, there's still a Chevron Step 1 in Chevron. It's not all Chevron Step 2, embedded in Section 111D. One of those that you've been talking about is the useful life reference, which I think is inconsistent with the whole notion of picking winners and losers that General Pruitt was talking about. And I think you're going to have problems there. But let's put that one to the side because you spent so much time talking about it. The other two key textual limitations are the fact that the statute is structured to give EPA the power to create procedure, not substance. And the second one is the source category limitation, which was your jumping off point for the 5 minute, it would take a court to reject that. It seems to me that those two limitations in the statute are very strong. They're framed in mandatory and very clear terms. Why, in your view, would they be rejected as Chevron Step 1 grounds for a challenge?
Well, so my glib remark about 5 minutes was about the second one, the categorical thing. So let me address that. So you have the basic idea of the Chevron case is that if Congress settles on one form of words, formulation, and that is crystal clear, then that crystal clear meaning has to be observed. But if there are gaps or ambiguities in it, the agency gets considerable discretion to resolve those. And by the way, I argued and lost the Chevron case, so I sometimes feel it's better to be really unhappy 30 years ago and pretty satisfied now than the other way around. But that's the principle in the Chevron case. Now, when you look at this particular statute, it turns out that Congress really kind of screwed up in 1990. They adopted two provisions in two different parts, two different sections of the 1990 Clean Air Act amendments that both modified the same sentence in Section 111. And the codifiers didn't know what to do. So they tried to pick one version of it and put it into the U.S. Code. But it turns out that what really is the law of the land is the statutes at large. And so you have to reconcile these two inconsistent amendments adopted at the same time to a single sentence of the Clean Air Act. If there ever was a place where the Chevron doctrine applies, it's got to be that, where the statute is literally it's like it's a failure to it's a mutation in the process of dividing and combining between the House and the Senate, and the agency is going to end up with the leeway to resolve that. And the EPA did produce a resolution of that in the Mercury. I believe it was the Mercury regulations, or maybe it was the more recent ones. And I think the Court of Appeals and the Supreme Court will literally spend
10 minutes.
Maybe together, 10 minutes, resolving that one. So on the other one, the question, again, what does the term procedure mean? What Section 111D does is it says, think about how it came to be. In 1970, they were writing this law. There was the section on ambient air quality standards. So there are these concentration values in the atmosphere and state plans to implement them. EPA sets the former, states do the plans, EPA judges whether the plans are going to meet those concentration values and approves them or disapproves them and issues federal implementation plans if they don't. Bump over to Section 111, and they wrote a section that said we should have new source performance standards for new plants. Bump over to Section 112, they said, which actually was carved out of Section 111 during the legislative process. They said for these special pollutants called hazardous air pollutants, we're going to have not only new source standards, but existing source standards set by the EPA. And very near the end of the legislative process in 1970, the drafters realized that they had a gap. They hadn't provided for regulation of existing sources of pollutants that are neither the ones for which the air quality standards are set or the hazardous air pollutant standards, but they are dangerous. They've been determined to endanger. And they wrote a Section 111D to fill the gap. And they provided that EPA would set a performance standard and the states would write implementation plans through a procedure like the one used to meet the air quality standards. That's it. That's how it came to be. And it's quite clear that it also says EPA has the same authority to approve and disapprove SIPs and to write federal plans as it does under the program to meet the air quality standards. It says that very explicitly. The plans have to be satisfactory to be approved. If they're not satisfactory, they have to be disapproved, and then there is a requirement to issue a federal plan. So again, I don't think there's much ambiguity there. If there is, it's going to get resolved as long as EPA is reasonable about the way they interpret it in the agency's favor.
So before we open it to questions, are there any panelists who want to make remarks, especially about the issue of the Senate and the House amendments that were both adopted in conference and whether they conflict or not and how that would be resolved?
Yes. Well, I can't speak to the legislative history that you've outlined, but you are outlining my worst nightmare, of course, as someone who works in Congress. Of course, it wouldn't be a nightmare to be actually legislating on subjects such as these. I think that would be very important. There is one part of the paper and one aspect of the debate as outlined in the paper that is jurisdictional to our committee, and I'm reminded of it by your comment, because I think in the Energy Policy Act of 2005, Congress went the extra mile to be very specific about certain power plant, certain demonstrations for purposes of Section 111D. And on page 8 of the paper, there's a good discussion. There's a long paragraph there that raises the issue that's engaged here with the question of whether carbon capture and sequestration is adequately demonstrated. And Congress, sort of the opposite situation to the one you're describing, was trying to harmonize laws and said very clearly in EPACT 05 that for purposes of 111D, you couldn't say that a technology was adequately demonstrated if it was a technology that was receiving assistance from the Department of Energy's Clean Coal Power Initiative. And I mention it. It's a mere footnote to the much broader and important question you're raising, but Congress doesn't always get it wrong.
No, listen, I love.
And I'm not suggesting that you are arguing.
I love the Clean Air Act. I mean, I think of. You talked about the founding brothers. I think of the people who wrote the Clean Air Act as this kind of second set of founding brothers. But that may scare you. I don't know.
I will disclose that one of my children is named after the first general counsel of EPA.
So on that point that you raised, what those provisions say is that, first of all, there's no reliance. I don't anticipate any reliance by EPA in the 111D rule on carbon capture and storage. But that has to do with the new source rule, the B rule. And what those provisions say is you cannot rely solely on a federally supported project to support the demonstration of a technology. And EPA's position is that they have not relied solely. They have a solid basis in facts that flow independent of, from projects and experience that has no EPACT support, that is sufficient to demonstrate that carbon capture and storage is demonstrated achievable technology for the new plants, and the EPACT plants would provide a kind of verification. But if you didn't have that, if they didn't exist, the standard would there's still a basis for the standard.
So
And yeah, Jeff, if I can just jump in, because of course there's a different side of the story on each of the points that David and others have discussed. And just very briefly, on the 111D limitations on authority under the clauses on regulation of pollutants under other sections, regulation of source categories under Section 112. The other side of the story is that there are two limitations. At the end of the day, they're both there in the statute, and they both should be applied. No pollutant that's regulated under 108, 109, or under 112, no source category regulated under 112 gets regulated under 111D. On procedure, the response is procedure is procedure, substance is substance. Congress knew what it was talking about when it talked about procedures. Look at 307D of the Clean Air Act that provides different standards for judicial review of substantive and procedural decisions. And on the Energy Policy Act of 2005, solely does appear, but solely appears in one of the clauses that limits EPA's authority with respect to consideration of technologies as adequately demonstrated. No technology, no level of emission reduction achieved solely by that technology or no level of emission reduction achieved shall be considered as the basis for an adequately demonstrated determination. That solely is confined to one clause, and that clause does not modify technology. So that's the other side of the debate on this, and that's what may take.
That's why it may take a little bit more time than 5 minutes,
May
right?
take a bit.
Maybe 15.
General Pruitt, did you want to say something before questions, or no?
No.
So, okay. So right before questions, actually, on the point that Bill was talking about in terms of the Senate version and the House amendments and the fact that both should be given effect, there's a paper that I'll commend to you that's up on the Federal Society website written by William Hahn, I believe, and in it, it covers that legislative history, and it basically takes the position that both the Senate and the House amendments are directionally deregulatory, and so it's going to be tough going for EPA and the courts, I think would be his prediction, if they tried to say that because they were the House and the Senate, even though in conference they adopted both, they're not identical, that somehow creates ambiguity and EPA can do whatever it wants and ignore the deregulatory purposes of both of those amendments. Would be pretty dicey for it to try. So take a look at that paper if you would. So with that, let's kick it open to the first question from the audience, if we could. Sir?
Greetings. I'm William Yateman from the Competitive Enterprise Institute. Thank you very much for the panel. It was wonderful. Quick question. I'm having a tough time wrapping my head around what a FIP would look like under a beyond-the-fence mass emissions 111D regime for greenhouse gases. Utilities normally plan on 4-year horizons with these integrated resource plans. Would a FIP under one such, this Kentucky plan or the NRDC plan, would it empower the EPA to impose, a de facto IRP, one of these integrated resource plans? And is that within the agency's technical and functional expertise?
It's me. It was, I'm glad I came.
I'm happy that
So my view is that what EPA, what a state plan will provide, if it's as it should be developed by the state, is it will impose an emission rate. This is the plain vanilla version. Impose an emission rate on the sources. Those that are over that limit would have a compliance obligation. Those that are under it, the state could choose to turn them into credit generators. The plan would also provide, well, what are the compliance tools that a source above the standard is entitled to use? And at least in our proposal, that would be, of course, things they do to ratchet the emission rate of the source itself down, by improvements to the physical plant. But it would also count credits through the kinds of approaches that we describe in our report for the change in dispatch from the historical reliance on to move towards a cleaner dispatch order, and credit for wind plants, the zero emission generation of wind plants built after the baseline, that would count. Uprates of nuclear plants would count. And as I explained, credit for the reduction in power demand by making our buildings and our homes and our appliances more efficient. Now, if the state chose not to do that, the question is, what would the federal government's plan provide? And it might provide only that same emission limit. And at that point, it would be, as it is under the Clean Air Act, it is always the prerogative of the state to resume the lead. If a federal plan, and I'm not speaking for the EPA, I don't know how they're going to do this, but this is just our idea. The federal plan would specify the emission limit. If the tools to bring all of those compliance measures into play are really state tools, well, that's the state's option. Bring them into play if you want.
Yeah, let me answer that a little differently. Under the Federal Power Act, FERC doesn't have authority to override, to dictate integrated resource planning at the state level, much less EPA. So that's sort of the first point. The second point is that this whole discussion sort of illustrates the difficulty you get into if you go beyond source-focused performance standards. So if you're focusing on what the performance standard of a source is, or what the performance of a source is based on best adequately demonstrated technology, theoretically, if the state doesn't adopt a plan and EPA has to, EPA has determined what's adequately demonstrated technology for the source category, for sources in that source category, and it could then go and look at, for the source, what's the appropriate performance standard, taking into account, as the statute says, things like remaining useful life of the individual facility. Now, as David says, that might not be as flexible as something the state could do in implementation. The state could always come back with its own 111D plan after that. But if you confine it to the scope of, to the proper statutory authority, what is the performance standard for the source, I think you avoid some of those problems you raise.
I would like to add that not only does the FERC not have the power to impose integrated resource planning, under the Federal Power Act specifically ousts FERC of any jurisdiction over electricity generation. So it's very clear that in the Federal Power Act that electricity generation is a state matter. And that, I think, goes along nicely with an inside-the-fence 111D analysis, if you will. I mean, consistent with the Oklahoma plan.
Yeah, and I would just, I mean, David, I really your comments have been constructive as far as our discussion here today, but it seems to me that the NRDC's approach, and hopefully not the EPA's approach, is that this section, provides substantive authority to the EPA, not procedural, which has a direct corollary effect on what the state can do. It converts the state's role from a substantive position to a administrative position or procedural position, and it takes away the authority of the states to contemplate the useful life that Bill's made reference to, in addition to these other factors on less stringent standards for a unit-by-unit designation. I mean, the statute clearly contemplates that.
Actually, those provisions are in the regulations and were created by EPA.
But
To reflect the statutory
and
term,
could be
among other
changed by
factors.
EPA.
But you're dismissing those factors at this point based upon this. Well, if you could reconcile, that would be helpful, because I'm trying to understand the reconciliation there.
Well, again, the statute says, and there's no denying this, that there needs to be consideration of remaining useful life. And what I've argued is that in a flexible structure, which does not command a unique limit for each source, but it has a limit for each source, but it doesn't command that it has to be met all by itself at that source. It has other tools available. Then the state and the source operators have flexibility to decide how long they believe it's valuable to operate that plan and to continue doing that by use of the flexible compliance methods. That should be welcome rather than...
If states have the ability and authority to determine a less stringent rate on a facility-by-facility basis, based upon physical impossibility, factors at the site, how do you achieve that if you are starting from the top down with a mass emissions approach? How do you achieve that?
Well, again, at least I don't expect EPA to set the standard in terms of mass emissions. I expect them to set the standard in terms of a rate of emissions. And I've explained that. So the question is whether, here's another way to look at it, that in the 1975 regulations that you're referring to, EPA was thinking at the time of standards that were set in the way that most of you are recommending. In other words, a uniform standard that's the same for every plant of a given type. And then it contemplated, in accordance with the remaining useful life language, that maybe there'd be something different about the economic position of one of those plants. So you need a variance. If you're going to have a uniform standard, you need a variance. That's the way they interpreted the statute to read, and then the regulations flesh out the procedures and the considerations that go into the variance provisions that EPA was thinking about at that time. But if you think about the standards differently, that they're not set on the basis that every single plant is the same and every single plant has to meet this by itself, then you have other mechanisms of compliance and other ways to take into account the underlying concern, which is that there should be, when plants have a different cost structure or a different situation, there needs to be a way to recognize that. So built into this flexible emission rate standard approach that we are recommending it's built into it that there is consideration of remaining useful life.
Of course, if I could just follow up on that, and this is a discussion that could go on the entire afternoon quite easily. When I look at the Oklahoma plan and others who have come out and emphasized that it's the state's responsibility to develop the plan, it's not about imposing a uniform standard of performance across a source category under 111D. It's looking at the technologies that EPA has determined are adequately demonstrated for the source category and determining first what is achievable at specific sources using adequately demonstrated technology, what is best in light of the statutory considerations, what is appropriate for the source in light of remaining useful life, and other factors that are particularly relevant at the state and local level. So that the plan would, far from providing uniform regulation of sources in a source category, would provide for tailored regulation of sources depending on the factors that I've discussed.
So before we go to another question, let me just hop in here because I think some of these questions, and I'm a specialist in the Clean Air Act as well, can get very abstruse. So let me try to tie it to something that maybe some of the more lay audience that we have today would understand. So the President Obama very famously said that, you can build coal-fired power plants, but if you do so, you will be bankrupt. And that approach seems to be running through all of the greenhouse gas regulations. And certainly, I think that will be part of industry's argument in challenging the rules if they go in the direction of making coal-fired power plants, existing coal-fired power plants, impracticable. Isn't the self-evident purpose of that language in the statute about considering the remaining useful life of plants something that was designed specifically, David, by Congress to ensure that that pre-existing investments in any technology, but in this case primarily coal-fired power plants, would not be effectively rendered useless or have their life cut short by a stringent regulatory regime? Wasn't that the purpose of Congress in 1990?
Well, first of all, that language dates from 1970, but no, I don't think that is I don't think there is a guarantee in the Clean Air Act that all the sources continue to remain as in the same economic position that they would be if they were allowed to continue discharging this dangerous pollution without any restrictions. I mean, the whole point of pollution control legislation is to internalize the cost of pollution, which is being imposed on the rest of us. Again, it's important, and I'm sure there's disagreement in the room about whether this is a serious kind of pollution, but again, I stipulate that it is, at least from our vantage point. And so when any kind of source is required to limit its pollution, its cost of operating changes. Sometimes actually it goes down. The car regulations have the fortunate impact of making cars cheaper to own and operate than they would have been if there were no standards, because of the payback and savings of of gas, the gas you don't have to buy. But sometimes, and probably most of the time, pollution regulations raise the cost of operating a source which is emitting pollution. And that's going to shorten its economic life, reduce its economic value. The question always is how much or what's the right balance, but you can't start with a proposition that Congress didn't want any of that, anything to change.
I'm going to show my ignorance here. I'm not a Clean Air Act lawyer, so please correct me, but I thought that the purpose of the Clean Air Act was to protect the public health and to reduce pollution. I didn't think and don't think that it's an economic statute whose purpose is to internalize the cost of pollution. I mean, that may be a consequence, obviously, of pollution control, but that from the point of view of a Power Act lawyer who works for the Energy Committee, that's precisely the kind of assertion about the reach of the environmental laws that is problematic from our point of view as people who are responsible for safeguarding the energy system and making sure that it's balanced. So I'm all for public health, and I really wasn't kidding when I said one of my children is named after the first general counsel of EPA. I really admire the work that was done in the early 70s, and you know, I'm all for pollution control, but internalizing the cost of pollution, while it may be a consequence, is not a purpose.
No, I didn't, and please don't mistake me. I didn't say it was a purpose. I said it was a consequence. And it is a necessary consequence of controlling pollution to meet a health or environmental objective, because it's to protect public health and welfare, which includes the climate. That's explicit in the statute, and the Supreme Court has so held. But when you do that, you cannot do that without, let me put it this way, you cannot do that and hold and have a purpose or a principle, a limitation, that you hold harmless the economic position of a polluting source. So I'm not saying it's our purpose to change the economic position. It's not. Our purpose is to control the pollution.
So
So
Jeff, I think
there's
that
actually-
consequence
Just
is why you have that language in the statute.
Yes. So, you know, we realize we've gone over a little bit, but General Pruitt has prevailed on me to take one last question from the back here, and then we'll close it out.
You've been very persistent.
Yes.
Oh, thank you. And gentlemen, thank you all for a wonderful discussion, including you, my dear cousin. That's right. No, David is always very sharp and very
He
informative.
claims to be my cousin.
I'm trading on that. It's really helped my career a lot, such as it is. But anyway, look, the original carbon pollution rule, which came out in March 2012, or April 2012, was deeply weird, because in that rule, the EPA decided that the performance standard for new coal power plants would be based on the emissions profile of a natural gas plant. And in effect, the EPA defined a gas turbine as an adequately demonstrated system of emission reduction for a coal boiler. And so it was a blatant fuel switching mandate, and I think that's maybe the main reason why they pulled it, why they had to have a redo, a do-over, because it is so obviously contrary to congressional intent. But it seems to me that these other options that are being discussed for existing power plants are very much in the same spirit. In other words, you're not going to require an existing coal plant to meet the emissions profile of a natural gas plant, but you're going to propose a performance standard or a performance standard guideline, which basically says each coal plant must split the difference between itself and a natural gas combined cycle plant. And so it's still very much a fuel switching mandate, it seems to me, what's being talked about here. And in fact, David, that was one of the options that you said states could use in order to come into compliance. And the question I would raise is, do you really think, does the panel really think that Congress intended that the 111D provision would be used to set standards for existing sources that no existing source in that category can meet, and that the only way that it can meet it is by reducing its operation, maybe even going out of business, and having the covered entity shift to a different type of facility. Does anyone think that that's a plausible reading of congressional intent?
My answer is probably shorter than David's. It's no.
Well, yes is about the same length.
Any last remarks before we close out? Thanks to all of our panelists, to General Pruitt, to Bill and David and Patrick, and to all of you and your patience. Thank you.